Swayam Prabha. Digital India. Educated India.
Greetings to one and all. I welcome you on the lecture series of Law of Banking and Negotiable Instruments. I am Dr. Rajamaji, Assistant Professor, Faculty of Law, Banaras Hindu University, Varanasi. In the lecture series of this banking law, this is the 19th lecture. Under this 19th lecture, I like to share with you the Foreign Exchange Management Act 1999. So this is very important as far as the law scholars, particularly when we are talking about the banking sector. It's a little bit, I would like to mention you that it's a little bit technical, but I'll try my best to make you easier to understand it. So we will discuss in the two lecture, the lecture 19 and the lecture 20, that is based on the Foreign Exchange Management Act 1999. And the first lecture we will discuss some of the very important aspects that is very important to discuss. What are the powers and functions of the Directorate of Enforcement? It is very important to know that what are the functions of authority which is provided under this act. So in the first segment, that is in this series of lecture 19, I will share with some of the very important aspects of the Foreign Exchange Management Act 1919. And in this regard, to make it very convenient to understand the purpose, the objective of the Foreign Exchange Management Act, before going to that, I would like to give some sort of, you can say, the highlights on the historical development of this act. What are the needs of this act? Why we require this kind of the act as far as concerned when we are talking about the banking business. And at the same time that I have decided to go with some of the definitions which is very important as far as concerned to understand the purpose, the objective of the banking as far as concerned that the Foreign Exchange Management Act of 1999. So for this purpose, these lectures aim to discuss the historical development of foreign exchange regulations in India. To understand this, the present lecture is divided in the following heads. So I have divided in the three very specific things as I have told you. Then we will, in the next lecture, we will discuss about the powers and functions of the Directorate of Enforcement. So going before that, we will have to see that what are the aims and objective of the foreign exchange. How that this act came into existence, that's a little bit we will give some focus on the historical development of the foreign exchange, and finally we will discuss under this lecture some important definitions given under the Foreign Exchange Management Act 1999. So when we are talking about the aims and objective of this act, it is very clearly mentioned under this the FEMA Act, which is very popularly known as the FEMA. So the main object of the Foreign Exchange Management Act 1999, that is called the FEMA, is to consolidate and amend the law relating to foreign exchange with the objective of facilitating external trade and payments and for promoting the orderly development and maintenance of foreign exchange market in India. Now that means the bankers, his business is not confined to the India only. So he has to go beyond or cross the border. So at the time when he is crossing the border, that how he can make the payment, how he can receive the money, that's the big issue for the banking sector. To regulate this, we'll have to see which we are calling that the foreign exchange. So it is very important that the foreign exchange, when we are making the payment through the bank, when the bank is receiving or when the bank is collecting the checks and the others, you can say the bill of exchange, if it is issued outside India, and if it is issued in India but the payment has to be made outside India. So these are some of the, you can say, the problems, and to sort out these problems, that the very specific act was enacted But this earlier, the attempt has been made to regulate the foreign exchange in the year 1973. But at the present time, we have the Foreign Exchange Management Act of 1999, through which we are regulating it. So that's why it's a very important that we'll have to see that what is the development, how it came into existence. As maybe that if we'll talk about the foreign exchange, so naturally the term itself indicates that there is a transactions that is beyond the country, or you can say that across the border. When we are going across the border, then we'll have to see that our currencies differ. So when the payment is made, how this payment can be done, that's a very big issue before is. So for that purpose, let me tell you some of the historical development of the Foreign Exchange Management Act. As part of the ongoing process of economic liberalization relating to foreign investment and foreign trade, there was an urgent need to regulate it. As I've told you, that due to the global market, it will be better to say, when the global market opens, naturally that the import-export business is very frequently taken place, and no country can live in isolation. So the country has to enter into the transactions with the others, and when they are entering with the others, particularly in the business community, so how the payment can be made or how the money can be received. So to regulate that, what we can say, the ongoing process of the economic liberalization, the foreign investment and the foreign trade, there was an urgent need to find some sort of, you can say, the enactment through which it can be regulated. So to regulate the foreign investment and the foreign trade, an act was enacted in the year 1973, known as the Foreign Exchange Regulations Act 1973. Here I would like to mention that the act was known as the Foreign Exchange Regulations Act, the Foreign Exchange Regulations Act. So the nomenclature, if you'll see, then it was very much you can confine to regulate the foreign investment or the foreign trade, because at that time it was necessary. So as with the passage of time, the act was found inappropriate to tackle the present situations. So when the act was enacted, and the purpose was to regulate the foreign investment or the foreign trade which were existed at the time. But the passage of time, as I have told you, particularly when the WTO, World Trade Organizations, came into existence. When the WTO came into existence, at the time we find that there is a need of, you can say, the global markets, and the market is open for each and everyone. So naturally, the India has also started investment money outside the country, and they required that. So naturally, the act was found inappropriate to tackle the situations which were existed at the time. So what happened that consequently, to cater the need of hour, it was felt that the Foreign Exchange Regulations Act 1973 must be reviewed, and it was reviewed in the year 1993. There were several amendments enacted. So that this is a general process when we have particular enactments in the hand of our country. So in the first and foremost thing, that we are not the process, we are not that repealing the process, that let us try to make some sort of, you can say, the amendment under this enactment, and it's a easiest way to amend any act. So in that purpose, that it was reviewed to meet out the need of the hour, and that happened in the year 1993, and due to it, the several amendments has taken place. So further, it was felt that the Foreign Exchange Regulations Act 1973 must be repealed. A task force was constituted to have an overall look on the subject and suggest the required changes. The task force submitted its report in the year 1994. That I have told you that when the amendment has been made, so even after the taking such kind of amendment, again the act was not found inappropriate to tackle the present situations or the situations which were existed at the time. It cannot be said that the act was inappropriate. The situations had changed. As when the global market opened, then naturally the new kind of, you can say, the challenges came before the bank to tackle all these issues. So in the circumstances, the task force was constituted to look give a overall, you can say, the look into the existing act, and on the basis of that, the task force submitted its report in the year 1994. When the task force submitted its report on the recommendations of the task force and keeping in view the significant developments that had taken place since 1993, the Foreign Exchange Management Bill was introduced in the Parliament. So it is very obvious that when the task force submitted its reports, on the basis of that, the new bill was formulated, and the Foreign Exchange Management Bill, as I have told you, the nomenclature has been changed. Earlier it was regulations, but now it is the management. So the Foreign Exchange Management Bill was presented before the Parliament. It was subsequently felt that a better course would to be repeal the existing Foreign Exchange Regulations Act and enact a new legislation. So the Reserve Bank of India was accordingly asked to undertake the fresh exercise and suggest a new legislation. A task force constituted for this purpose to pursue and submitted its report in the year 1994, recommending that substantial changes in the existing act. Significant development have taken place since 1993, such as substantial increase in our foreign exchange reserves, growth in foreign trade, rationalizations of tariffs, current account convertibility, liberalizations of Indian investments abroad, increased access to external commercial borrowings by Indian corporates, and participations of foreign institutional investors in our stock markets. As I have told you, that due to the globalization, liberalizations, and particularly as I have told you, in the year 1995, when the WTO, World Trade Organizations, came into existence. So naturally, that the work were going on before that. So in this regards, that it was felt during that you can say the period, we felt that the existing act which will have, and the task force which were working at the time, they were taken into considerations the what are they expected that what kind of things in the near future may take place due to the enforcement of, or you can say the effectiveness or the functioning of the World Trade Organization. So the significant development have taken place, as I have told you this, since 1993, such as the substantial increase in our foreign exchange reserves, growth in foreign trade, rationalizations of tariffs, current account convertibility, liberalizations of Indian investments abroad, increased access to external commercial borrowings by Indian corporates, and participations of foreign institutional investors in our stock market. So naturally, it was very obvious due to this scenario or the situations, by keeping in view of the change in government, the central government has decided to introduce the Foreign Exchange Management Bill and repeal the Foreign Exchange Regulations Act 1973 due to, as again I would like to mention here, that the government felt that there is a need of the repeal the previous act, that is the Foreign Exchange Regulations Act of 1973, and in place of that will have to enact the new legislation. So the provisions of the bill aim to consolidating and amending the law relating to the foreign exchange with the objective of facilitating external trade and payments and for promoting the orderly development and maintenance of foreign exchange markets in India. As I have told you the earlier, that only that we were very much confined to what the foreign investment and the foreign trade. But now that the work has expanded, you can say, and that has to be managed. So for that purpose, that we need some sort of the act which will manage all sorts of, you can say, the which is related with the foreign exchange. So by keeping all the things in the provisions of the bill aim to consolidate and amending the law relating to the foreign exchange with the objective of facilitating external trade and payments and for promoting the orderly developed and maintenance of foreign exchange markets in India. So finally, it is very things, as I have told you, that the journey has ended with that. The Foreign Exchange Management Bill, having been passed by both the houses of Parliament, received the assent of the President on 29 December 1999. It came on the statute book as the Foreign Exchange Management Act 1999, and it came into force on 1st June 2000. Again, I am repeating it, that as I have told you that we have started as far as concerned to regulate the foreign investment, the foreign trade from the 1973 with the help of enacting a specific legislation to regulate the foreign investment, the foreign trade, and that was regulated at the time with the help of the Foreign Exchange Regulations Act 1973. But as I have told you that it is not the loopholes of the act, it is not the loopholes of the legislature, it is only due to the changing the scenario of the global market. And the global market, as I have told you, that we found the new institutions, the World Trade Organizations, and the World Trade Organizations bring the so many new things as far as concerned in the foreign market, the foreign investment, and due to that the foreigners they willing to invest in our country because now the market is open. So naturally that the role of the foreign exchange increase, and due to that we find that there is a requirement of the new kind of, you can say, the legislations, and we have repealed the earlier one and we got the new, that is the Foreign Exchange Management Act 1999, and it came into force on 1st June 2000. Now, as I have told you that in this segment we will discuss only the three part, the one aims and objectives which I have already stated before you, and the second thing, as I have told you, the historical development we will see, and the third things which I am talking about, that some of the important definitions, unless and until we understand these definitions, we cannot understand what kind of the functions is rendered by the Directorate of Enforcement, because in the next lecture, as I have told you, that we will discuss about the Director of Enforcement. Now, see, for that purpose, we will have to see some of the definitions which is very important. Although, as I have told you, it's a very technical terms has been used under this act, but we will try to understand one by one so that at least we can reach to the conclusion that what do mean and how does it regulate, and what are the powers and functions and how these powers and functions is exercised, and if any persons who is found in contravention of the provisions of this act, what kind of the penalties has been provided under this act. So as I have told you that to understand the foreign exchange management, we will have to discuss certain important definitions. Now, I'll begin with the definitions because there are the various kind of the persons terms has been used, the currencies has been defined, the services has been defined, the every kind of things which we have available in the general dictionary, that is not taken into consideration, and that's why intensely the act defined in the different way, and we'll have to take care of it, and accordingly the act taken into consideration as one concerned when he is considering or adjudicating through the adjudicating authority. So the first term which I like to say with you, that is the foreign exchange. The foreign exchange term has been defined under section 2 clause N of the act. Now let me tell you the three important things has been taken into consideration as fine concern that when the act defines the foreign exchange. Foreign exchange means foreign currency and includes, that means the two things. The foreign currency means which is not Indian currency. So the foreign currency, apart from that it includes other things. That means the foreign exchange is not confined to the foreign currency. As I have told you that we will see that what do you mean by the Indian currency, that is a different issue, but as far as the general understanding that the foreign currency means which is not our currency, that's why we are calling the foreign. So, but it includes, what are these? The three things has been included under this. One, it is talking about the deposits, credits and balances payable in any foreign currency. That means that the what in your positions we can say, the other than the Indian currency, if the any deposits, the credits, the balances payable in any foreign currency. So the things which either in the deposits form, whether you have credited to someone, or the balances available in the account in what form? In the form of foreign currency. So that will term as foreign exchange. The second thing which has been incorporated, it says the drafts, traveler's check, letters of credit or bill of exchange expressed or drawn in Indian currency but payable in any foreign currency. Again, the very important things which is included. What are these? The drafts, the bank drafts and others, traveler's check, letters of credit, bills of exchange, expressed or drawn in Indian currency but payable in any foreign currency. The draft which you have issued, the check which you have issued, the letters of credit, the bill of exchange which you have expressed or drawn where in Indian currency. The things are drawn in Indian currency, but these are payable in foreign currency. So that also included under what? That is also included under the definitions of foreign currency. The third very important thing is that the draft, traveler's checks, letters of credit or bill of exchange drawn by banks, institutions or persons outside India but payable in Indian currency. That means if you look the third one, it is talking about the drafts, traveler's check, letters of credit or bill of exchange drawn by banks, institutions or persons outside India but payable in Indian currency. That means anything which is drawn, whether it is in form of the checks, whether it is in form of the, you can say the drafts or in the traveler's checks or any letters of credit or bill of exchange drawn by banks, institutions or persons by whom? Who are not reside in India. So the outside India, that means it is drawn in, it will better to generalize, it is drawn outside India but it is payable in Indian currency. So now the three things are very clear. The one thing that if anything which is foreign currency, that will come under the definition of the foreign exchange, and the other things which are included, the deposits, credits and balances payable in foreign currency, and the two things are that drafts, traveler's check, letters of credit, bill of exchange expressed or drawn in Indian currency but payable in foreign currency, and the certain other things, it is the same way it is talking about the drafts, traveler's checks, letters of credit or bill of exchange drawn by banks, institutions or persons outside India but payable in Indian currency. So all the things are included under the definition of a foreign exchange. So when we will find that the persons, if contravening any kind of, you can say, the provisions of this act, so this term plays a very significant role. Now I'm coming to the, as I've told you that it's a foreign currency. So we'll have to understand what do you mean by the Indian currency. So the Indian currency term has been defined under section 2 clause Q of the Foreign Exchange Management Act 1999, and it defines as the Indian currency means currency which is expressed or drawn in Indian rupees but doesn't include a special bank notes and a special 1 rupee notes issued under section 21A of the Reserve Bank of India Act 1934. Again I am repeating it. The Indian currency means currency which is expressed or drawn in Indian rupees but doesn't include a special bank notes and a special 1 rupee notes issued under section 21A of the Reserve Bank of India Act 1934. That means we can understand that every kind of the currency, the Indian currency, that will covers under the either in form of the 1 rupee note, that is what we are calling the currency of this country, and the others, the rupees 2 onwards, what we have, these are the banknotes. So each and every banknotes are included under the definitions of Indian currency as far as concerned section 2 clause Q of the Foreign Exchange Management Act. But on the other hand, when we are talking about then a special the banknotes which is used for the specific purpose when there is any kind of, you can say, the requirement to make convenient, or you can say to make easiest in the circulation of notes outside India. So the special notes, the bank notes are there, or a special 1 rupee notes which is issued for the purpose of that purpose by the Reserve Bank of India Act 1934, that will not covered, and the remaining, that is the either the currency or the banknotes, these are covered under the definition of Indian currency. Now the foreign currency, again it is defined under this act, and it says the foreign currency means any currency other than the Indian currency. So in contrary to that, if you'll see that section 2 clause M, which defines the term the foreign currency, and it says the foreign currency means any currency other than Indian currency. So we find the three very important definitions. Again, I would like to make you clear Why? Because this term plays a very significant role when we will discuss the further. The one thing that the Indian currency means, except the special banknotes and the special 1 rupee, any currency which is in circulations in Indian, that is the 1 rupee and the other banknotes, these comes under the definition of a Indian currency. Apart from that, the Indian currency that is talking about, that will term as the foreign currency, because if you read the section 2 clause M, it says the foreign currency means any currency other than Indian currency. Now, when we are talking about the foreign exchange includes both the transactions. So the foreign exchange means the transactions as well as the foreign currency. The both terms are taken together. That's why the definitions have been made. The foreign currency and includes, what are the includes? The things which is made in India but payable in foreign currency, and the second thing is which is made outside India even if it is paid in Indian currency. So these all kind of, the drafts, the checks, the bill of exchange, all the things are included under the definition of a foreign currency. Then again, another terms which we define under section 2 clause O, that is foreign security. The foreign security. Let me read out the provisions. The provision says the foreign security means any security in the form of shares, stocks, bonds, debentures, or any other instruments denominated or expressed in foreign currency, and includes securities expressed in foreign currency but where redemptions or any form of return such as interest or dividends is payable in Indian currency. Now, the two part of this, the foreign currency, when we are talking about that the security as far as concerned, then we'll have to see that any security, the terms has been used, the any security. What? In form of the shares, in form of the stocks, in form of the bonds, in form of the debentures, or in any other instruments denominated or expressed in foreign currency. That means the shares we should have. If it is, for example, if the value is mentioned in dollar, that means it is foreign security. If any debentures, and irrespective of where it is issued, that is not a matter. What we'll see, the denominations that is made in the foreign currency, that means the value that is made in other than the Indian currency term, that will comes under the definition of a foreign security. That security may be in form of the share, stocks, bonds, debentures, or any other instruments denominated or expressed in foreign currency, and includes securities expressed in foreign currency, but the redemptions or any form of the returns such as interest or dividends is payable in Indian currency, that will not included under this definition. Now, as I have told you that the two important things as far as concerned, that the foreign trade, when we are talking about, then we will have to understand what do you mean by the import and export. The foreign trade means the import and export terms when we are using, that means we are using for what? When the transactions is made beyond the country or outside the country. That means when the jurisdictions, outside of the jurisdictions of any country, if they are in the general way we can say that any kind of the transactions, whether the things is coming to India or the things is going from India to the other country, so we'll have to see that. So that these terms has been defined again under clause L, section 2 clause L, which defines the term export, and it says export with its grammatical variations and cognate expression means the taking out of India to a place outside India any goods. And further, clause 2 says provisions of services from India to any persons outside India. That means export, when we are talking about exporting, that means you are sending goods from India to outside. So that is similarly that the service which you are rendering, because now there are some sort of like this, the internet services or the services which because the satellite, the services and other things that is shared by the country to other country. So if any kind of the charges we are taking and the things which is situated, or when it is better to say that from the India, if any services which you are sending to or rendering to outside of the country, or any goods which you are sending outside of the country, that will covered under the definition of an export. And in the same way, the import term has been defined. That term has been defined under section 2 clause P, and it says the import with its grammatical variations and cognate expression means bringing into India any goods or services. In other way, we can say that it's just vice versa, that when we are talking about the sending the outside, then we are using the term that is the export, and when we are getting or the things is coming from outside the other country to India, then we are talking about that we are importing it, whether it may be the service or it may be the goods. Now, the general term which has been used under this act, that is the currency. The currency, as far as concerned, that when we are talking about, if we'll go through the definitions which are given under the Negotiable Instruments Act of 1881, then the currency means there is only one thing, as far as concerned, that if we'll talk about the India, that the Indian currency is the rupee, that is 1 rupee. So again, I would like to recall here that the 1 rupee, if we'll see, although it is issued by the issue department of the Reserve Bank of India, but you do not find any kind of, you can say, the promises over there, because it is mandatory. So when we are talking about the demonetization, the 1 rupee note cannot be demonetized, because there is no any kind of the promise has been made. So it is our currency, so it will continue, and it is not issued by the signature of the Governor RBI, the Governor Reserve Bank of India. It is issued by the signature of the Secretary, the Finance Ministry. So this is the difference between the currency and when we are talking of the banknotes. The remaining notes, the rupees 2 onwards, whatever the current, you can say the currency or the notes, banknotes which will have, that is signed or that is issued with the signature of the Reserve Bank of India. The 2 rupees, the 5 rupees, the 10 rupees, the 20 rupees, the 50, the 100, the 200, and the 500 rupees will have. If you go through, then you will find that the promises we made on behalf of the central government, that is made by the Governor Reserve Bank of India, and he promised that if you go through the content of the note, the banknotes, then you'll find there is a promise, and the promise has been made that I promise to pay the sum of things which is mentioned in that particular note to the bearer. So that is that the undertaking which has been made, that can be withdrawn, and when we are talking about that has been withdrawn by the central government with the consultation of the Reserve Bank of India, so we are talking about that the monetizations has taken place. So the currency is the different things, but as far as concerned, as I have told you, that why the terms currency has been defined under this act, because the intention of this act is to include the other things under the definitions of a currency. So let me tell you that the terms has been defined under section 2 clause H of the act, that is Foreign Exchange Management Act 1999, and it says the currency includes all currency notes, the postal orders, money orders, checks, drafts, travelers checks, letters of credit, bills of exchange, and promissory notes, credit cards, and such other similar instruments as may be notified by the Reserve Bank. Again, I am repeating it, as far as concerned, that I have told you that the currency, when we are talking about the currency, why the currency term has been defined, because the purpose is to include the other things. So when we are going through the definitions which is given under the section 2 clause H, then you will find the currency is not confined to the 1 rupee or the banknotes. It is extended to what? It includes all currency notes, postal notes, postal orders, money orders, checks, drafts, travelers checks, letters of credit, bill of exchange, and promissory notes, credit cards, or such other similar instruments as may be notified by the Reserve Bank. That is very important to mention here, that when going through the definitions of the currency which is defined under section 2 clause H under the Foreign Exchange Management Act 1999, then you will find that which things are included under the definitions of a foreign exchange, these are also covered under the definitions of a currency, and they very clearly mention that it includes all the currency notes, the postal orders, the money orders, checks,
draft, traveler's check, letters of credit, bills of exchange, and promissory notes, credit cards, or such other similar instruments. That is not confined. Again, that the power has been conferred to the Reserve Bank of India. The Reserve Bank of India may, from time to time, it can add any other kind of instruments, and that will become a part of the currency, as fine concern that when we are taking into considerations or when we are defining currency under the Foreign Exchange Management Act 1999. And similarly, that further it is defining the currency notes, and it says the currency notes and includes cash in the form of coins and the bank notes. The currency notes which we are talking about, that is included, and it has been defined under section 2 clause I of the act, and it says the currency notes means and includes cash in the form of coins and bank notes. Now, as far as that when the transactions is based on it, so how the transactions can be made. So for that purpose, there are the different kind of, you can say, the transactions can be made. So for that purpose, we'll have to see the few definitions. And the first definitions which I have taken, that is given under section 2 clause J. This section defines the term the current account transactions. So the current account transactions. Let me read out what are included under this. It says the current account transaction means transactions other than a capital account transaction and without prejudice to the generality of the foregoing, such transactions include. That means if we'll see, then it says the transactions means transactions other than the capital account transaction. That means they are the capital account transactions has been defined in a different way. So apart from the capital account transactions, that everything will come under the definitions of a current account transactions. And what are these? Clause A says the payments due in connections with the foreign trade, other current business, services, and short-term banking and credit facilities in the ordinary course of business. Further, clause 2 says in payments due as interest on loans and as net income from investment. And further, clause 3 says remittances for living expenses of parents, spouse, and children residing abroad. And further, clause 4 says expenses in connections with foreign travel, education, and medical care of parents, spouse, and children. Let me explain these provisions. If you'll see that, as I have told you, that apart from the capital account transactions, everything is included under the current account transactions. And if you'll see the current account transactions, then the first thing we'll have to see the payments due in connections with the foreign trade or other businesses, services, and short-term banking and credit facilities in ordinary course of business. So to meet out, you can say the day-to-day, you can say the transactions that is included under the term the current account transactions. And then further it is talking about if any sorts of, you can say the payments are dues in terms of the interest on loans and net income from investments, that is considered as a current account transaction. And further it is talking about the remittances for living expenses of parents, spouse, and children residing abroad, if any things which is met out for the purpose of what? For the expenses, living expenses of the parents, spouse, or the children if they are residing abroad. And finally it is talking about the expenses in connections with the foreign travel, education, and medical care of parents, spouse, and children. So these things are covered under the definitions of current account transactions. And when the current account transactions will be made, that you'll have to provide, you can say the prescriptions that on which heads the amount will be expended. Now, I'm coming to the next definition, that is services. As you have already seen the security, now I'm coming to the services. As we have read, when we have read the two definitions, that is import and export. So import and export, then we have seen that the ones, the word which is used, the goods, and the other one the services. So in the regard, it is very important, and the term has been defined under section 2 ZB, under section 2 clause ZB, and it defines the term service, and it says the service means service of any descriptions which is made available to potential users and includes the provisions of facilities in connections with banking, financing, insurance, medical assistance, legal assistance, cheat fund, real estate, transport, processing, supply of electrical or other energy, boarding or lodging or both, entertainment, abusement, or other purveying of news or other information, but doesn't include rendering of the any service free of charges under the contract of persons and the other things. Apart from that, if you see that the definitions which is very important, we'll have to see, that is the persons. When we will discuss the power and functions of the Directorate of Enforcement, at the time the persons terms has been used. So the persons, we know that who is the persons, but as my concern, this act defines that who is a person. So when we are talking about the persons includes, and the definitions has been given under section 2 clause U. They are the 7 categories of the persons which are included under the definition of a person. I am not saying that whether the natural persons or the unnatural, or you can say the legal persons. When we will go through these 7 categories of persons, then we will find that all these categories, whether it is the natural persons or the artificial persons or the persons who is created by any statute or the persons which is created by any law. So by reading all these 7 clauses, we find that all the persons, all kind of, you can say, the persons are included under the definition of a person. So it has been defined under section 2 clause U, and it says the person includes who are an individual. The first one is an individual. So that individual, when we are talking about, that means he is the natural person. Clause 2 is talking about the Hindu undivided family, and short we are calling that HUF. The Hindu undivided family, that is also treated as a person. So you know that there are the systems which are prevailing in our country, that is joint family. So the Hindu undivided family, if they have, so they will treated, they are given as a status of a person. And the clause 3rd, it is talking about a company. As you know, the company is created with a statute form, and at present time what we will have, the present time we have an act, and that act is known as the Companies Act 2013. Companies Act 2013. The body of persons, the association of persons, if they are registered under the Companies Act, they will term as a company. And the clause 4 is talking about a firm, that we know that there is a farm partnership act. So any persons who is a part of that part, he can be considered as a person. Further, clause 5 is talking about an association of persons or body of individuals, whether incorporated or not. It's a very important provisions which are made under this act to treat as a person. Now see, as I have told you, the statutory, then that the form through a particular statute. But see that it is talking about the association of person or a body of individuals, the association of persons or the body of individuals, whether it is very important, whether incorporated or not. Even that means that if the group of persons, if the body of the 10 individuals, they will treat it as a person under this act. Why? Because it is talking about if they are incorporated, it's all right. As I've told you, who are incorporated, either you are incorporated under the Partnership Act or you are incorporated under the Companies Act of 2013. So it is your choice. But even it is talking about, if you'll see the clause the 5, then it is talking about even the association of person or body of individuals, whether incorporated or not, they will covered under the definition of a person. Further, clause 6 is talking about every artificial judicial persons not falling within any of the preceding sub-clauses, and that means the every kind of, because the artificial judicial persons, those who are created by the judiciary, or it will be better to say that by the created by the any law, those who are not, you can say that prescribed under clause 1 to clause 5, all are comes under the every artificial juridical persons, they will also come under the definition of it. Finally, it is very important things which have been mentioned under that to consider, that is a person, that is any agency, office or branch owned or controlled by such persons. So the above all, that is the 6 category of persons who are treated an individual, a Hindu undivided family, a company, a firm, an association of persons or body of individuals, whether incorporated or not, and every artificial juridical person not falling within any of the preceding sub-clauses. And as I have told you that through all these persons, any agency, office or branch owned or controlled by such persons, they will come under the definition of a person. Now, when we find that the persons, these are the, you can say the 7 category under this we find that all are considered, whether it is an individual, whether it is a firm, whether it is artificial, whether it is created by a corporate or not, it doesn't matter. If they are carrying any sorts of, you can say, agency, the other things, they all are included under the definition of a person. So now we'll have to see the persons. We have categorized these persons in the two, the one, the persons who is not residing in India, and the other, the persons who is residing in India. So let me come to the first one. The first one, it is talking of the persons resident in India. So the persons who we can say that he is resident of India. So when the term has been defined under section 2 clause B of the Act, and there are the many things which has been taken into consideration, and on the basis of that the persons is considered that the persons is residing in India, and we are calling it the persons resident in India. Let me allow this section 2 clause B, which define the terms person resident in India, and it says, it means, clause 1 says a person residing in India for more than 180 days during the course of preceding financial year, but doesn't include H1 concern. The first thing is that if any persons, if he resides in India, that is more than 180 days, the days is very important, more than, that means the minimum requisite number of days to reside in India that has been mentioned under that, and it can be considered that he is a resident of India. The person is resident in India. What is that? The first and foremost thing what is required, that it is mentioned that the minimum, you can say, to a stay, that is 180 days. How the 180 days will calculate? Then it says during the course of preceding financial year. So in the preceding financial year, we'll have to see if the person resides in India for the period of more than 180 days, he can be considered that he is the persons of resident in India. But at the same time it says, but doesn't include, who are not included. The clause A category says a person who has gone out of India or who has stayed outside India. In either case, if the persons, if he is not residing in India, he went outside India, in the 3 very important things which have been mentioned, for or on taking up employment outside India, the persons who went outside India for getting an employment, he is not included. Clause B4, it is talking about for carrying on outside India a business or vocation outside India. And further, clause C is talking about for any other purpose in such circumstances as would indicate his intention to stay outside India for an uncertain period. Now, in the first category of the persons, those who are excluded, one, that the persons, if he went for the employment, whether he has resides in India, even the minimum number which is required, that is more than 180 days, so that will not be taken into consideration. It is not the matter. Why? Because the persons leave this country for what? For searching of the employment. And the second thing, if he is carrying out the business outside India. And the third thing, it is if the persons went the outside India for uncertain period, there is no any kind of the period has been mentioned by him. So in these 3 category, that will not be treated that he is the resident of India. The second category, it has mentioned, and it says a person who has come to or stays in India in either case, otherwise then. The 3 category, again it is mentioned, the for or on taking up employment in India, if he has come India for the purpose of what? For the purpose of taking up employment. The second category, for the carrying on in India a business or vocation in India, or for any other purpose in such circumstances as would indicate his intention to stay in India for an uncertain period. So the same kind of, you can say, the things has been mentioned. The only what is required, the persons who has come to or to stay in India in either, otherwise then. And there are the second category of persons, it says that any persons or body corporate registered or incorporated in India.
that it doesn't matter that the persons, whether he is residing outside India, what is very important, if the persons is registered or incorporated in India. When we are talking about the incorporated India, that means the persons or the associates of persons, they were registered under the Indian laws. The third, it is talking about an office, branch or agency in India owned or controlled by a person resident outside India. Again, I am repeating it, an office, branch or agency in India owned or controlled by a person resident outside India. And the finally fourth category, it is talking about an office, branch or agency outside India owned or controlled by a person resident in India. Now come to the persons resident outside India. It's a very simple, the provisions has been made, and that definitions has been given under section 2 clause W, and it says the person resident outside India means a person who is not resident in India. That means the under clause B, who is resident in India, other than that persons, they will come under the definition of the person resident outside India. Now, as far as concerned that when we are talking about the regulations and management of the foreign exchange, so in this regard, we'll have to see certain things which is very important. As far as concerned that when we'll look, then we'll have to discuss the section 3 of the Act. The section 3 are the two very specific things which is talking about. That is, as we have already seen, what do you mean by the foreign exchange. So the section 3 is dealing about the dealing in foreign exchange, etc. Let me allow to read out the provisions which he made. It says, save as otherwise provided in this Act, rules or regulations made thereunder, or with the general or special permissions of the Reserve Bank, no person shall. What are the clause A says, deal in or transfer any foreign exchange or foreign security to any persons not being an authorized persons. So the very important thing, so we will see the authorized persons. Say it says that no person shall deal in or transfer any foreign exchange or foreign security to any persons not being an authorized persons. And further clause B says, make any payment to or for the credit of any persons resident outside India any manner. So it will better to say by reading these two provisions that whatever the transactions, whether in terms of the foreign exchange or the foreign security, that has to be done through what? That has to be done through the authorized person. Now, the holding of foreign exchange that is made under the definitions that given under section 4. The section 4 is talking about the holding of foreign exchange. It says, save as otherwise provided in this Act, no persons resident in India shall acquire, hold, own, possess or transfer any foreign exchange, foreign security or any immovable property situated outside India. That means it says that no person resident in India, they cannot acquire any sorts or hold, own, possess or transfer any foreign exchange, foreign security or any immovable property situated outside India. Now, further the section 5, which is talking about the current account transactions, which you have already discussed, how the current account transactions can be made. The provisions have been made under section 5 of the Act, and it says any persons may sell or draw foreign exchange to or form an authorized person if such sale or drawal is a current account transactions. It says provided that the central government may, in public interest and in consultations with the Reserve Bank, impose such reasonable restrictions for current account transactions as may prescribe. Again, I am repeating it. Section 5 is talking about the current account transaction, and it says that any persons may sell or draw foreign exchange to or from an authorized persons if such sale or drawal is a current account transaction. So it is free to enter into the transactions, but to with whom? That is the authorized person. The capital account transactions, it is also made in the same way, and it says that the subject to the provisions of the subsection 2, any persons may sell or draw foreign exchange to or form an authorized persons for a capital account transactions. They are the other provisions which he made under subsection 2.
this says the Reserve Bank may, in consultations with the central government, specify what are that? Any class or classes of capital account transactions involving debt instruments which are permissible. And further it says the limit up to which the foreign exchange shall be admissible for such transactions. Further, clause C says any conditions which may be placed on such transactions, provided that the Reserve Bank or the central government shall not impose any restrictions on the drawal of foreign exchange or payment due to on account or administrations of the loans or for the depreciations of any direct investment in the ordinary course of business. But the powers has been conferred to the central government, and the central government may, in consultations with the Reserve Bank, prescribe any class or classes of capital account transactions not involving debt instruments or such are permissible. The limit up to which the foreign exchange shall be admissible for such transactions, and further clause C says any conditions which may be placed on such transactions. Further, subsection 4 it says a person's resident in India may hold, own, transfer or invest in foreign currency, security or property was acquired, held or owned by such persons when he was resident outside India or inherited from a person who was resident outside India. Further, if we'll see, then it is talking about under section 6, which has been very clearly mentioned, the person resident outside India may hold, own, transfer or invest in Indian currency, security or any immovable property situated in India if such currency, security or property was acquired, held or owned by such persons when he is resident in India or inherited from a person who was resident in India. And finally, subsection 6 says, without prejudice to the provisions of this section, the Reserve Bank may, by regulation, prohibit, restrict or regulate the establishment in India of a branch, officer or other place of business by a person resident outside India for carrying on any activity relating to such branch, office or other places of business. Now, in a very brief, just I would like to mention here that the export of goods and services, that provisions has been made, and in this regard that the things can be done under section 7 of the Act. I am concluding by mentioning the section 8, which is very important, that is realizations and repatriations of the foreign exchange. It says save as otherwise provided in this Act, where any amount of foreign exchange is due or has accorded in any person resident in India, such person shall take all reasonable steps to realize and repatriate to India such foreign exchange within such period and in such manner as may be specified by the Reserve Bank under section 8 of the Act. Now see, in the circumstances when we'll see, then I'll like to mention the two very important things. As I've told you that the definitions which you'll have read will have to keep in mind that the foreign exchange, the foreign currency and the other powers which have been conferred under this Act. As far as concerned, the two very important things which I like to mention here, that when we'll exit further, that the one terms which I have used, the authorized persons, and that the who can be authorized, that will be determined by the Reserve Bank of India. So, in a final verdict that I would like to mention here that the some of the powers which have been conferred to the Reserve Bank of India, but as far as concerned the adjudicating authority, that the powers has been conferred to the officers which has been appointed under the nomenclature of Directorate of Enforcement. So, we will see in the next lecture, which is also related with the power and functions of Directorate of Enforcement. Thank you very much.